All right, this is just a continuation from the questions video which I just made. All right, so Dr. Michelle Dow can invoke her right against self-incrimination under certain circumstances, particularly when her answers, their answers. This is not a woke thing. Her answers may expose her. To criminal liability, right? So this is protected from by Section 13 of the Canadian Charter and by common law principles. So we know that, for example, a criminal case, you can say, listen, I don't want to answer your question because I can I incriminate myself, right? However, in civil proceedings, the context is different from criminal trials. Self-incrimination in civil discovery. So the Canadian Evidence Act and provincial equivalents typically provide that answers given during discovery in civil cases cannot be used against the person in criminal proceedings. Okay, so the evidence, the rules of evidence are extremely important because if you violate the rules of evidence in a trial, that's an appealable issue, right? So you get an appealable issue, which can lead to a mistrial. So you really cannot use the evidence. I'm not really interested in a criminal proceedings. Criminal proceedings are not my duty. I'm not a prosecutor or anything like that. I certainly would like to see her behind bars for a period of life without the possibility of parole for 25 years. To be served concurrently to all of the children that she died. She literally killed more in excess of 1,000 people, small boys and small girls. So she belongs in the prison. But like I said, the rules of evidence are very, very clear. We must respect the rules of evidence because if we don't, then that's an appealable issue, right? So we don't want an appealable issue because that just, causes mistrials and a whole bunch of wasted time and money. And so again, right? The rules of evidence, provide that answers given during discoveries, like a civil case, cannot be used against the person in criminal proceedings, right? With some exceptions like perjury. And therefore, a person simply cannot simply refuse to answer questions on the basis that the answers might incriminate them, because statutory protection usually prevents those answers from being used to prosecute them criminally. Right? So if the person refuses to answer anyway, you can apply to compel them to answer, and a judge can order them to do so. Right? So you can get this judge to compel them. Right? So that's really really important here. They must answer the question, and that's the whole point about my faith has just been restored in this here. That's very very important to realize here because I thought that wow, this thing, she's just going to, say, well, I would love to answer the question, but on the advice of my lawyer, I plead the fifth, right? So it's not, pleading the fifth. It's just, invoking my right against, self-incrimination, right? But it doesn't work like that, right? It works because of the rules of evidence, right? I love the rules of evidence because it makes sense. Right, the rules of evidence are very important. They're there for a reason, right? So when might a refusal be allowed, right? If there's an active criminal investigation, but there's not, right? Or a realistic prospect of the charges, well, there's not, because we live in a country like, Canada. The court may allow the witness to refrain from answering certain questions temporarily. However, a blanket refusal is unlikely to succeed unless the risk of criminal jeopardy is compelling and immediate. The civil consequences of refusal: if she refuses to answer on self-incrimination grounds without a valid basis, the court may draw an adverse inference, especially in a civil context. Yeah, it could be, but it's not. You're not actually guaranteed the protection against self-incrimination is I think was this talking about. So let's say for example, in a criminal setting, you're invoking your right against self-incrimination. No adverse inference can be made. For example, yeah, it can affect credibility or bolster your case if the refusal appears strategic or evasive. Yeah, for example. Sure, sure. So if you're preparing a damning discovery question, it's best to carefully tie each question to a legal issue or element of the case, right? There's going to be, the questions that I had in my previous video. I mean, these are not the questions, right? These are an example of what questions could look like, right? And anticipate the relevance and how refusal would appear. right? Yeah, and be ready to challenge refusals through motions to compel answers. And these motions will certainly be, granted. I do believe that these motions are fair and that they're not vexatious, contrary to the earlier motion that we've seen earlier, a motion to for summary judgment, right? That's a vexatious motion that we can almost guarantee is going to happen, and it's very, very likely that it will be dismissed, right? I don't expect the motion for summary judgment to be granted. But I do expect the motion to compel the answers when she starts saying, on the advice of my lawyer, I'm going to plead the fifth. Right? Pleading the fifth is for a civil. For a criminal offense, right? A criminal offense. You cannot expect the guy to be compelled to testify against himself, right? That's what the Miranda rights are all there for. You have your Miranda, you have the right to remain silent. Anything you can say will be used against you in a court of law. That's the whole Miranda. If you will, if you will arrest a suspect and you will not Mirandize him, and he's found guilty, then that's an appealable issue. You didn't Mirandize my client. He can, walk free. And some deadly psychopath, lunatic murderer can literally walk free out of the courthouse because they didn't Mirandize him, right? Why is the rules of evidence so important, right? Maybe we can talk about that in another video, but the rules of evidence are extremely important. And this here, the right to self-incrimination, the right against self-incrimination, is a constitutionally protected, in many countries. But the thing about that is, in civil proceedings, there's a different context because this cannot be used. Let's say, for example, she does, self-incriminate. That evidence cannot be used in a criminal case, and that's really, really important to remember. Great point. I don't know why I temporarily forgot about this, but it makes sense now that we revisit this issue, right? So thank you very much for tuning in. I'll see you in the next video. Take care and enjoy your day. I'll see you. Bye bye.